Welcome to our 650 webinar, Navigating Expected Employment Law Changes Under the New Trump Administration. We've got a lot to cover today. We still have quite a few people who are joining. So while they're joining, let me just get a couple of the preliminary matters out of the way. First, feel free to let us know where you're joining from in the chat. We always love to see where people are joining from. I will also say that it is Girl Scout cookie season, so feel free to put into the chat also your favorite flavor of Girl Scout cookie. I have some strong opinions here, so let us know where you're coming in from, and if you have a favorite Girl Scout cookie, let us know. I love seeing, we usually get people from all across the United States, and it's fun to see. I'm seeing lots of people putting their location in there. Let me answer a couple of preliminary questions that we get during every webinar. First, will you receive the slides? The answer is yes. We will send the slides out after the program with a follow-up email. Two, is there going to be a recording of the webinar? Yes, you will receive a recording of the webinar with that follow-up email as well. A couple of other preliminary things I want to cover. We would love for this to be an interactive program. We're covering a lot of interesting things. We'd love to hear about your experiences. If you have questions, please use the Q&A function at the bottom of your screen. That will allow us to track those questions better. The chat sometimes gets fast and furious, and I'll be honest, I can't follow everything that's going on in there. I'm glad usually there's a lot of networking and other things, but if you put your questions in the Q&A, then we can track them a little bit better. But feel free to network and chat in the chat. But if you have substantive questions you'd like us to answer, please use the Q&A function so that we can track those. Okay, well, we've given people 2 minutes to join. I'm seeing some great answers to the Girl Scout cookie question. This is an unofficial survey, but I'll tell you the results at the end of what I think are the best cookies. And it looks like, again, we have people from all across the country. So thank you so much for joining us. We're really excited to have you here for what we think will be a very interesting discussion. My name is Ryan Parker. I'm the Chief Legal Officer here at 650. I think many of you, as I look at our participant list, have been on a 650 webinar before, but for those of you that are new, welcome. We're glad that you're here. 650 is an HR platform that helps companies of all sizes to navigate all the different employment requirements, especially things like creating employee handbooks, creating state-specific offer letters and employment agreements. And because of those tools, we have a legal team that's tracking all sorts of legal developments that affect things like employment policies and employee handbooks and employment agreements. And so we're tracking these laws so we can send out monthly updates to our customers so we can update our tools. And as we do that, you know, it gives us a good opportunity to be to then present that information in webinars. And so we're really excited to be able to do that today. I'd like to introduce, let me just say one more thing before I introduce our speakers. Many of you are here to get HRCI, SHRM, or CLE credit, and we will be giving you the codes near the end of the program. We'd ask that you write those down because we cannot send those out afterwards. So if you could write those down, we'll give you plenty of time to do that. But those codes will be coming at the end of the program. I'm excited to have 3 co-presenters with me today, and I'm going to introduce them in the order that they will be presenting. I'll take the first section, and then I'll be kicking it over to Seth Baraney. Seth is a legal product counsel here at 650. He loves music festivals, comedy shows, and is a proud graduate of The Ohio State University. In this time of national division, you're going to see a rare moment of unity here as a Michigan Wolverine congratulates Seth, an Ohio State Buckeye, on his football national championship this year. So congratulations, Seth. That was a lot easier to do knowing that we won the head-to-head matchup, but I'll just leave it at that. No, we're really grateful to have Seth. He works on a host of different issues, including our consumer data privacy issues and a lot of different privacy issues. After Seth, we'll turn the time over to Josh Baca. Josh is a legal product counsel here at 650. He is an avid outdoorsman. Josh is my go-to person when I'm looking for new hiking and backpacking gear, and is known in our company for making everyone jealous with his pictures of his various outdoor adventures. And we're really grateful to have Josh with us today. After Josh, we'll turn it over to Connor Christensen. Connor Christensen is a legal product counsel here at 650. He is 650's resident bird watcher. He is really astute at watching birds. He leads bird watching walks in Northern California, and often will post in our general fun channel pictures of the birds that he's seen, which is a lot of fun. So we appreciate Connor. Connor is the mastermind behind our employee handbook tool and spends a lot of time thinking about policies and how changes affect those policies. And we're really grateful to have him on today as well. So with that, let's get started. I'd like to start right off the bat with a poll question. You're here because there's a new administration. You're thinking about it. Every new administration brings employment law changes. So with this new administration, what changes are worrying you the most? Are they the changes to the EEO rules and enforcement? And I would put those DEI changes under that as well. Changes to EEO rules and enforcement. Changes to immigration enforcement. I know that's something that I've seen in a lot of the HR forums that I'm on that people are worried about. Potential changes to the employee contractor test. Changes to federal contracting rules. That's an interesting one. And then the potential for increased changes to state employment laws. I keep seeing people say all of them. Totally fair answer. Choose your favorite here. We won't hold you to it, but let us know what you're thinking about. There are a lot of things going on, and together they can feel a little overwhelming. So let's see what people are thinking. We'll give you just another moment. Federal grants. You know, if it's federal grants, put that under changes to federal contract. That's one I should have added to the list, so I apologize. But let's see what our answers are. We'll pull that up here. Okay. Wow, we got a lot of different things. Changes to EEO rules and enforcement. That's been one that's gotten a lot of publicity, and we'll be talking a lot about, especially DEI programs, what that means for employers. Seth will be addressing that. Changes to immigration enforcement. I'll be touching on that briefly. Potential changes to the employee contractor test. A couple people. Changes to federal contracting rules. We had some there as well. I think that's an interesting one. And then the potential for increased changes to state employment laws. I think that's a big thing that's going to come out of this administration. We'll talk more about that. Well, I think that we'll be able to hit most of those, and I really appreciate you jumping in on the poll. It gives us a feel for what you're thinking about, and I think that we're going to be able to hit most of those topics. Let's move to the agenda, and I'll just give you a quick overview of what we're talking about here. So we'll start with executive orders and litigation. This will be a little bit of an overview of things that are going to change and things that may stay the same in the Biden administration. Then we'll kick it over to Seth, who's going to talk about DEI and EEO changes specifically. That's been a real hot button issue in the employment law space. Josh is going to talk about administrative leadership changes. And this is, I think, an area that's not talked enough about that could bring some real changes to the way that employment laws are enforced and interpreted. And then Connor's going to talk about how we can deal with the unpredictability that is brought by a new administration and that we'll likely see here as states pick up, some of these issues that the federal government is likely to step back from. So that's what we're going to cover today. Why don't we jump right in to a look back at the Biden administration, and we'll do this quickly, but the Biden administration really took significant efforts to protect employees. And actually, for many of you that have joined other 650 webinars, I think we did a 650 webinar on each of these four things at one point in the year. And so let me just stop and give a plug. If you're interested in sort of continued content, feel free to go to 650.com. There's a resource tab at the top. You can click that and see all of our webinars, including recordings of past webinars. But Stericycle was a big change during the Biden administration. That was an NLRB decision to strengthen protections for against policies that might stifle an employee's right to engage in collective action. And I know many of you probably had to go back into your employee handbooks and make changes or add disclaimers or look at that. That was a big change from the NLRB. The employee contractor test. It's interesting, both the Biden and the Trump administration, the previous Trump administration, said they were using the economic realities test, but the Trump administration previously had adopted a much more lenient test that allowed employers to categorize more people as contractors, really looking at only two factors, the nature and degree of control over the work and the worker's opportunity for profit and loss. The Biden administration went back to a multi-factor test that was intended to have more individuals be classified as employees. And that was a big change. And I think that's likely to go back. The Biden administration under the FTC tried to ban non-competes on a federal level. That rule has been enjoined by a federal district court in Texas. It was subject to a lot of litigation, but that was a significant effort to protect employees. And finally, the Biden administration through the DOL tried to increase the exempt employee salary thresholds for the different categories of exempt employees. And that was going to be a significant salary increase for a lot of employees. We even saw some employers who increased, they gave their employees raises, and then when the rule was struck down, have taken those raises back. So that was a way that the Biden administration tried to help employees. And so I think that's really been a hallmark of the Biden administration, is federal administrative action meant at protecting employee rights, increasing their benefits and their salary. So that's kind of what we're coming from. Let's look at where we're going, and we'll jump into the next slide. What is likely to change and what is likely to stay the same? I think the Trump administration is likely to roll back employee protections. I think we're already starting to see that. I think the employee contractor test will go back to a test that allows employers to classify more individuals as contractors. I think we'll see them just go right back to the test that we used during the first Trump administration. I think the non-compete ban and the increase in exempt employee salary thresholds are likely dead. Whether that means that the Trump administration won't appeal those rulings that happened in the district court, or whether they'll be withdrawn, or a combination, remains to be seen. I know that there are some third-party groups that are trying to intervene in those lawsuits to keep them alive. That is, I think, in my view, unlikely to be successful. And so I think that we'll see those efforts sort of disappear. And then maybe most significantly, and this is something that Josh is going to touch on in greater detail, we will see leadership changes at the EEOC, the FTC, the DOL, and the NLRB, and that's already happening. But with that leadership change, we'll see those different agencies take a less proactive approach at protecting employees. So before coming to 650, I actually worked at the Department of Justice as a career attorney, defending constitutional challenges to federal actions. And I was there during administration changes. And we used to joke that when an administration changed, the lawsuits actually stayed the same. The only thing that changed was who was bringing them and where they were being brought. And I think that's what we're going to see again. As you saw in the last slide, there was a lot of litigation over the Biden administration's attempts to protect employees. I think we're going to see a lot of litigation here in the Trump administration as well. The only thing that will change is who brings those suits and where they will be brought. Almost every suit against the Biden administration was brought in Texas. That's where the non-compete ban was stayed. That's where the salary threshold was stayed through federal courts in Texas. You will now see, I think, cases being brought in California, Massachusetts, Washington, some of those states instead of Texas. And we actually are already seeing that as far as Trump's other executive orders. And some of these have effects on employment and some don't. But for example, Trump's executive order on birthright citizenship was already stayed by a federal judge in Seattle. I think we're going to see a lot of litigation in Seattle. And then the attempt to freeze federal grants. I saw someone in the chat mention that as one of their major concerns. That was stayed by a federal district judge in Washington, D.C. And so we're going to see a lot of litigation, just like we did during the Biden administration. And I think some of it's going to be successful, but litigation always injects into, for businesses, uncertainty. And I think we'll see a lot of uncertainty. Let's move now to the next slide and talk a little about executive orders. One of the things that's gotten the most publicity during the beginning of the Trump administration has been the dozens and dozens of executive orders that we've seen. And we could touch on a lot of different things. There's things like energy production, ending government diversity, equity, and inclusion programs, and Seth will talk about that, defining sex and gender, immigration, health and medical research, birthright citizenship. Trump even issued an executive order renaming changing geographic names. Lots of things there. And those things have made it so, it's hard to keep track of all of them. And so we're going to touch on just a few of these things that have a direct effect on employment law. And there are other things that we won't be able to touch on during this webinar, and hopefully we'll have an opportunity to touch on in future webinars. As I mentioned, one of the things that we've seen a lot of discussion on HR chat boards and others, and as people said they were concerned about in our early polling, was what about immigration enforcement? And we have already seen news stories about immigration enforcement actions going on in different cities. New York City, we're based in Salt Lake City. We heard about immigration enforcement action there as well. And I think a lot of employers have been concerned about what that means for them and what happens, what they need to do to be prepared for increased immigration enforcement. And I broke it down into two sections. This is sort of an area that we do touch on and an area we don't. And I'll start with the one that we have a little more familiarity with, and that is I-9s. Employers should make sure that they are collecting and keeping properly completed I-9 forms. That's been a requirement for a long time. Hopefully you're already doing that, but now is a good time to go and make sure that your process is working and that you have all of your I-9 forms in order. As a reminder, you need to have a completed I-9 for each of your current employees. And when an employee leaves, you need to keep their I-9 for either 3 years from the time they started employment with you, or 1 year from the time that they left employment with you, whichever of those two is the later. And so now is really a good time to make sure that you have your I-9s in order in case ICE officials come and want to do an I-9 audit. I think that's something that hopefully you don't have to experience, but I think it is something that you want to be ready for. And so now is a good time to make sure that you have those processes in place and that your I-9s are organized and that you're keeping them for the right amount of time. Maybe the thing that there's been the most chatter about when it comes to immigration enforcement is what happens if ICE officials, and that's immigration and custom enforcement officials, show up at my workplace. And I think that can be terrifying for employees, it can be terrifying for employers, and is really something that I think a lot of employers should be thinking about, especially if you think that you work in an area, either the nature of the work that you do or geographically where you're likely to come into contact with ICE officers. And so I think there's some things to think about. One, I think it's important for you to understand your rights. So you can work with an attorney, maybe a business association or a community group to understand what your rights are. For example, ICE officers don't necessarily have the right to just come into private office space without a judicial warrant. And so, it's helpful for you to understand what your rights are there. I think one of the most important things you can do is determine who will be the point of contact for your organization, right? You don't want a situation where all of your employees feel like they have to be able to, and a great point, it needs to be a judicial warrant, not an administrative warrant. Good comment in the chat. But you don't want your employees, all of your employees, interfacing with ICE officers. If they come, they should be trained or told to direct the officer to the point of contact for your company. And you can have one person who is prepared to talk to the ICE officers and have those conversations. That could be an attorney, it could be an HR leader, but figure out who that is. And then really, if you think this is a concern, consider training your employees in how to respond if ICE officers enter your workplace. And so I do think, this is an interesting thing for businesses to think about, but I think it's important because it is on the mind of employees and employers. So be proactive, think about what you need to do and put a plan in place. I think that's sort of the best thing that you could do to be ready for these types of situations. So that's kind of what I wanted to talk about just with enforcement, immigration enforcement and those orders. I'm now going to kick it over to Seth, who's going to talk a little bit more about some of the EOs and maybe a little bit more broadly about executive orders and what they can and can't do. So Seth, take it away.
Thanks, Ryan. So yeah, we're going to dive into kind of the specifics of the two big executive orders Trump has already issued around DEI and EEO in the workplace here in just a moment. But before we get into kind of the meat on those particular bones, I thought it might be helpful to just kind of stop and talk about kind of what the president can and can't do acting autonomously. Because if we've seen one thing from this administration so far, it's that they're going to try and advance their agenda in a lot of different ways. And they're going to try to pull a lot of the different levers that are available to the president. And as Ryan has kind of mentioned, once the litigation gets going, we'll kind of get to see what levers he can and cannot pull. But kind of looking from the outside, we can already make some kind of guesses and some understandings about what EOs are going to be upheld and which ones maybe aren't. So starting kind of big picture, what can't the president do via executive order? They can't create, amend, or repeal federal law. And I have an asterisk there because when we say federal law, oftentimes we kind of think about all types of binding rules that might be made by the federal government. And what I'm talking about here is statutes, right? So the president can't just write an executive order saying, Title VII is gone because Title VII is passed by Congress. That's a statute that's there. They don't have the power just to change that or repeal it kind of at will. In the same vein, right, they can't amend the Constitution. They couldn't put something out just saying the 14th Amendment is donezo and it take effect. And they can't really, this one's a little bit nuanced, but they can't really impose new requirements for private employers without relying on some existing authorization from Congress itself. And what I mean by that is the president can't just go out one day and say, I want private employers to do X, Y, and Z. And they just write it down on an executive order and they sign it and they're done, right? The way that Congress theoretically could just come up with a new law that says we want employers to do X, Y, and Z, right? Presidents can, change the way they interpret and enforce federal laws, which we'll talk about in a second. And that can sometimes allow them to create new requirements through an executive order. But they always have to be tied to some existing kind of grant of authority. And the last thing they can do, really the area they have maybe the most authority is to direct the operations, or sorry, what they can't do is to direct the operations of independent federal agencies. And on the flip side, they can direct the operations of the executive state pretty much completely, right? The biggest way they're going to do that is changing how agencies enforce federal law. Which can, again, have a pretty impactful force, like they're changing a law or creating a new requirement, but it's just kind of done a different way. If you're familiar with back when Obama was in office and the state started legalizing marijuana for recreational uses, there was a memo that Obama sent out basically saying, hey, Department of Justice, put this on the very bottom, marijuana convictions on the very bottom of your enforcement priority list. And so, in that way, while he wasn't able to change anything in the DEA or in the classifications of those drugs federally, the enforcement priorities were able to change in a way that kind of has that same effect. They can also argue for different interpretations of the Constitution in court, and if a judge agrees with them, then those things can kind of have that weight of changing the Constitution. They can impose requirements on employers based on new interpretations of existing law. Which is kind of like what we talked about a minute ago, and they can make appointments to fill vacancies in these independent agencies. The independent agencies being things like the NLRB, the EEOC, the Federal Reserve, things like that. And as Josh will talk about here in a minute, even that power is kind of qualified because they can only remove and replace these vacancies kind of according to a term limit or subject to certain restrictions. So big top-down kind of view there, a lot of information, but I thought it was just kind of helpful to set up because that's what we're going to see in these next EOs are very creative ways that this administration is going to try and change the law around DEI and EEO. And so we have here, there's really two primary orders that have been passed pretty much right after Trump took office that are going to have the meat of the requirements as they exist today. And maybe there's some legalese kind of way, a reason that we should talk about them separately and think about their requirements as being separate. But for our purposes today, I think we can really just kind of think of them as the same kind of set of actions. They functionally advance the same goals, which really you can put into two categories. They are trying to stop any activities that promote the use of illegal DEI in the federal government, right? Which is kind of squarely a thing the president can do, direct the federal government to stop prioritizing race or gender when they're making hiring decisions. And then the second piece, which is maybe a little more interesting and a little harder to predict, is that they're directing the federal government to find ways to encourage the private sector to end illegal discrimination and preferences. And just a couple things there that we're going to talk about that I think are going to set up this kind of conversation is we don't really know what illegal DEI means at this point. And that's a term that Trump uses throughout the executive orders. but doesn't specifically define. And I think that's really going to be what comes down, what kind of the million-dollar question is in terms of how this administration is going to enforce these laws and what that impact is going to be on private businesses is what practices, like how much can you consider DEI type values before you cross into the realm of illegal. And we will touch on that again a little bit later. And the second big question is just what does that word encourage mean? Right? Like how is the federal government going to try to get the private sector to change its practices in this regard? And we can make some guesses and some inferences that I think are helpful, but until we actually see them start to, encourage, there's always going to be a little bit of uncertainty around that. But on the next slide, we can talk about the first piece of these orders, which is how exactly are they directing the federal government specifically to end these practices, and how might it affect the private sector? And we won't spend too much time on this because I imagine that we don't have too many people here representing a federal agency. And so if you do, I'm sorry, the content's going to be a little more geared toward private organizations, but we'll touch on it a little bit nonetheless. So the biggest piece here is, like I said a minute ago, just no more using diversity, equity, or inclusion principles in any federal hiring or contracting decisions, right? And he did that through repealing a bunch of executive orders that basically made it mandatory for the federal government to take these things into account. So now there will be no ability to say, we want to have a racially diverse or a gender or sex diverse workforce within the federal government, at least specifically. And that doesn't really affect private employers, at least, except insofar as it might affect the sort of pool of talent available in general. But the next piece, I think, has the potential to maybe be the first kind of form of encouragement that the administration is going to try to kind of change private behavior here. And that is that all federal contracts and grants that are issued kind of moving forward will have to have a provision in them where the contractor or the grant recipient will have to certify that they don't engage in any types of DEI that violates federal law. And then they have to agree that the contract or grant can be terminated if the federal government were to find that they were engaging in that kind of DEI. And I think, if we're kind of wondering about who's going to feel the pressures from this administration to change first, I think the answer is contractors, federal contractors, and federal grant recipients. Because it is a lot easier for the administration to come in and say, hey, we don't like what you're doing in the diversity space. We're not going to sue you. We're not going to have to go through all that trouble of winning a court judgment, but we are just going to take this grant away. And we're going to take this contract away because that's just within the purview of the federal government. We don't need to get into kind of the administrative difficulties that can come from other avenues of enforcement. So if you are a federal contractor or you rely a lot on federal grants, I think you really want to prioritize kind of looking at your DEI principles and maybe revising them in the ways that we're going to talk about here in just a minute to kind of avoid that illegal DEI potential there. So that's the federal piece, the first big chunk these do. On the next slide, we'll talk about the private side, the kind of how are they trying to encourage folks in private practice to make these changes. And really what they're doing is directing the federal government to kind of come up with some ideas for the Trump administration in terms of how they can do that. Right. There is no specific ban in these executive orders that say private businesses, have to do X, Y, and Z, or we're going to create this new threshold or standard for folks to use in DEI. But what there is a directive to the entire federal government, every agency and every department head there is, to assess their own sector of the economy and basically identify all of the private organizations that are engaging in illegal DEI in your kind of sector. Then they have to identify at least 9 targets for potential compliance investigations. And then they also have to kind of think about other strategies and potential regulatory actions that might be able to advance this goal, right? And if we kind of remember back to what I was saying at the beginning about what presidents can and can't do, I think kind of the core of this is basically help me, the president, figure out what levers I have available to pull. Like what existing grants of authority from Congress can I rely on to kind of advance this goal? Which I think says, unfortunately, if for people trying to kind of comply at this point, that we don't know what they're going to try to do to make these changes because I don't think they know exactly what they're going to try to do to make these changes. So this is going to be an area that you really are going to want to keep an eye on once we start seeing these. They might release the report publicly once it's due, I think 120 days after the EO, so sometime in the spring. Or they could start announcing these regulatory or compliance investigations or what have you. And it's through those developments that I think we're really going to get the best insight into, okay, like what exactly do we need to worry about? What exactly do we need to change? Yeah, so there's a little bit of uncertainty. I think there is some information we can grab onto, though. It's not just kind of freewheeling and chaos, but I do just want to say that we are at the very beginning of this. And I think that the main function of these EOs, at least in terms of how they affect the private industry, is kind of asking for a roadmap. And that roadmap doesn't quite exist yet. So unfortunately, there's an element of just kind of be patient here, and wait to see what happens next. But that being said, we do have some action items for you, which start on the next slide, which is going to be, we do have an idea of what illegal DEI might mean. And that's really helpful because what we can say for certain at this point is that whatever enforcement the Trump administration tries to take, it is going to be targeted at companies that do illegal DEI, right? And that's all over the executive orders, and it's been all over his rhetoric since taking office. And to kind of talk about what illegal DEI might be, I think it's helpful to maybe take a step back and just look at like federal anti-discrimination law from kind of a big picture, right? And that law, things like Title VII, basically prohibit businesses from making hiring decisions or employment decisions for like promotions and firings and all that on the basis of people's protected characteristics, right? Race, gender, national origin, sex, all these different things that are kind of protected characteristics. In historically and kind of up until now mostly, that has been interpreted to mean you can't take adverse actions against people on the basis of these characteristics, and it's largely been kind of viewed as an affirmative action measure, right, to kind of help minority racial and minority demographic groups access opportunities that they might have a harder time accessing otherwise. But what I think we're going to see with the Trump administration is kind of flipping that concept on its head a little bit to say, okay, if you're deliberately hiring someone or promoting someone based on their diverse characteristics, which a lot of companies, use race as sort of a heuristic for that, then that is making a decision based on that person's race, even though it is a positive decision for them. It's going to kind of be reframed as a negative decision for all those people that were passed up for the hiring or for the promotion. Right. And so that's kind of that core idea is going to be using race or gender or national origin or any of these protected classes in and of themselves as a reason to hire or not hire or promote or not promote someone. I think that's going to be the kind of core issue that this administration is going to go after. And the question is really going to become, how far are they going to go? Right. And I think it's a little bit unclear in employment law just how far that idea can be taken. But I think we can look to how the Supreme Court handled educational affirmative action recently. In that case I cite there, Students for Fair Admissions versus Harvard, which is really, I think, about as far of an extreme as you can take that idea out to. It was adopted back in 2023, and it basically says any consideration of a person's race in and of itself that is like specifically accorded in the hiring process is illegal, regardless of whether it is but one factor considered in a bunch or if it is like the solely determinative factor. Any type of honest and like straightforward consideration of a protected characteristic could be enough to consider it illegal DEI. And so if you're a risk-adverse organization, it probably makes sense to hew close to the most extreme end of this, because we've already seen that this court is willing to go that far in a similar context, right? And they might not in this, but at least by kind of taking that as a starting point, you can set yourself up to say, it's pretty unlikely that it's going to be more extreme than that, if that makes sense. And again, we will learn a lot more about this as enforcement around these executive orders begins, right? Because the administration is gonna have to make arguments in court for why certain uses of DEI are illegal. And then when those arguments get sued over how they interpreted it, they're gonna have to kind of produce more evidence and more argument about what they believe that term means and what laws it comes from. So take these things into account, but really, really pay attention kind of to what's coming down the pipeline, because this is going to be developing hot and fast over at least the next 6 months or so. Okay, moving into my last slide here, just a couple action items, which I think we already kind of hit on. But the biggest thing you can do here is evaluate all of your internal policies and procedures around hiring and firing and promotions and transfers and those sorts of things to basically find out where any protected characteristic is being considered kind of blatantly and clearly and given weight in that process, right? You might have a written policy, it might just be a practice, but what you really want to figure out how you can avoid using those protected characteristics really in and of themselves as much as you can, at least until we have more understanding of what and how the administration is going to interpret that. And so I think there's a little bit of daylight in that for, in that you can promote a diverse workforce, but you need to think about diversity a bit more broadly, kind of as like a person's whole of their experience, and kind of advocate for that rather than using a protected characteristic as a sort of shorthand. Instead of thinking, oh, we will achieve diversity by virtue of having diverse race or diverse sex or diverse whatever. It's kind of got to be, we will have a diverse workforce by having individuals who are all different from one another, regardless of what their characteristics might be. And that can be a narrow and confusing line to walk, but I think that is kind of the space we're in, at least until we get further clarity from the administration on this. So it's kind of a do the best you can for now and then see where we go from there. And that is all I have. So I will now kick it over to Josh, who's going to talk about some of the changes the administration has made in leadership and those kinds of things.
Awesome. Thank you, Seth. So yeah, as Seth mentioned, I'm going to talk about personnel changes today and not the actual law. So my part of this webinar is going to be particularly speculative. And I hope you take what I'm saying with a spoonful of salt, because people are not as easy to read as a statute. So as you know, there have been a slew of firings recently at basically every federal agency. I'm just going to talk about 4 of them today and how the turnover there might affect private businesses going forward. I'll first give you a quick rundown of each person's history, and then I'll try to sum up what I think is likely to happen with the agency at large. So at the DOL, first, the Secretary of Labor, Julie Su, was terminated on January 20th. Sue has been known for her pro-workers' rights leanings, and while at the DOL, she had a hand in the passage of the recent rule raising salary thresholds for minimum wage and overtime exemptions. She was also part of the proposed rule that would prohibit employers from paying less to disabled workers. On the next slide, we'll see some replacements. So to replace her, we have Republican Vince McConey, who is currently serving as the interim labor secretary. McConey's already begun kind of retooling the DOL, directing staff to immediately cease and desist enforcing government contractors' observance of anti-discrimination laws and affirmative action initiatives. And in a kind of surprising move, Trump nominated Republican Lori Chavez de Remer as the new labor secretary. And this nomination's turned a few heads because she has some pro-union, pro-labor leanings. For instance, she supported the Protecting the Right to Organize, the PRO Act, which provides greater labor protections for employees to collectively bargain, and the Public Service Freedom to Negotiate Act, which would basically guarantee the right to public service workers like teachers and unions to join unions and collectively bargain. Now, what these changes suggest for the immediate future, we can see a couple of points on our next slide, is that we can expect further action against DEI programs and offices, as you probably expect based on what Seth was talking about. And what that means for private employers is that any employers who are already under the microscope or had a fear of coming under investigation for DEI violations are really not in any danger of further prosecution. And if we try to look further forward than that, it gets a little more difficult. The current labor secretary nominee has some of the same leanings as the current secretary, so we could possibly see a revival of certain things like the exemption wage threshold rule, though the overall political climate makes me feel like that's kind of unlikely. Chavez de Remer's focus seems to be on union activity and bargaining processes, so I expect she'll focus on building more of those protections. And the impression I get from my quick dive into her history doesn't make me think she'll bother to do much about keeping the prohibition on sub-minimum wage alive. Next, let's talk about the EEOC. So on Monday night, just this week, 2 of the 5 EEOC commissioners were fired. Charlotte Burrows, the acting chair, and Jocelyn Samuels, both Democrats. One interesting thing about their firings is that the Civil Rights Act states that all members of the commission shall continue to serve until their successors are appointed and qualified. Now, there's debate over whether the president has the authority to fire them without there being successors in place, because now there really isn't. And both commissioners are considering their legal options, and there's really significant debate over how that will go. As to their backgrounds, both of them lean left, with Commissioner Burrows having started the hiring initiative to reimagine equity, and Commissioner Samuels supporting gender equality through the National Women's Law Center. And as we see on the next slide, not only were commissioners let go, but the EEOC also saw loss of their general counsel, Carla Gilbride. Her termination was pretty much expected, though, because President Biden did the same thing during his presidency, and the move was ultimately upheld in court. Before working for the EEOC, though, Gilbride litigated wage theft and employment discrimination. She was also co-director of the Access to Justice Project, helping individuals find their way through the court system. For replacements, there technically haven't been any real replacements at the EEOC, but Andrea Lucas, who has served as commissioner since 2020, has been appointed to acting chair following Burrows' termination. Lucas has worked in the private sector before with employers advising them on discrimination and sexual harassment issues. She's also an outspoken proponent of what she calls colorblind equality. She has given numerous speeches and written articles declaiming the legality of affirmative action, stating that civil rights law requires employment decisions to be made using purely merit-based qualifications, and that race and gender should play no part in decision-making. Implications of this, we see that the EEOC being made up of 5 commissioners and losing 2 of them with a current vacancy means that there are only 2 commissioners on in the commission, leaving them without a quorum. So that doesn't bring everything to a standstill, but it really does limit the board's actions or the commission's actions to only the routine and basic duties. Without a quorum, they can't promulgate rules or make impactful decisions. Also, because both commissioners intend to challenge their dismissal, we're not likely to see a return to normalcy soon, since litigation can take a long time, as you know. Despite the lack of a quorum, though, and the inability to do business, with Andrea Lucas as chair, I expect we'll see a big shift away from DEI programs, like in the DOL and enforcement, both in the EEOC itself and with its contractors. This is a trend I think we'll see moving more into the private sector space as time goes on. The EEOC is responsible for supporting anti-discrimination laws, among other things, and DEI initiatives have largely been intended to help reduce discrimination. Regardless of whether you think DEI programs kind of level the playing field or are in themselves acts of discrimination, kind of as Lucas seems to, this administration has made it clear that DEI is unlawful in its eyes. And because the EEOC is responsible for enforcing anti-discrimination laws, I think it's likely we'll see 3 things happen. 1, I think there will be a decrease in enforcement actions brought under some of our current anti-discrimination laws as the agency reinterprets its stance. 2, we'll see some rulemaking efforts to limit DEI programs in the private sector, because currently they're still permitted. And 3, I think that will probably be followed by an increase in enforcement actions against those employers who keep their DEI programs in their current form. Now, many employers are probably thinking of retooling their current DEI programs, looking for a better name, something like maybe workplace fairness or something. But what I gather from Lucas's interpretation of civil rights law is she likely takes issue with the word equity in favor of the word equality. Equality being that everybody gets the same thing, and equity meaning that people coming from disadvantaged states might get an extra leg up. The next agency I'm going to talk about is one we've talked about plenty in previous webinars, the FTC. Now, the FTC's probably had the smoothest transition so far. Last month, Andrew Ferguson was named as the nomination to be chair of the commission during this new administration, and there was debate as to whether the current chair, Lena Khan, would step down or would kind of push back. Last week, though, she issued a memo informing her intention to resign. And I believe her last day is actually supposed to be tomorrow, with Andrew Ferguson taking over as chair on Monday. Now, during her tenure, Khan was a strong proponent for workers and consumers' rights. She was a large part of the push to ban non-competes nationwide. She helped finalize different rules requiring businesses to make it simpler to cancel subscriptions and rules prohibiting employers from using shady pricing practices. She was also part of the effort to block big business consolidations that would have resulted in raised prices and lower wages. Now, as I mentioned, replacing Khan will be Andrew Ferguson, and we can take a look at him on the next slide. He's already taken various steps to enforce the president's order to reduce DEI through government agencies. One of his known goals as chair is to end big tech's vendetta against competition and free speech. When Ferguson was named as chair, Mark Meador was also nominated to fill the vacant seat on the commission. There was already a vacant seat. Meador previously worked at the FTC, the DOJ, and for Senator Mike Lee, but always working in antitrust matters. During his time with Senator Lee, he even drafted legislation that would have broken up Google's ad tech business. One thing these replacements seem to have in common with Commissioner Khan is a wariness of big business, big tech in particular, and a kind of a willingness to keep them in check. And what that means looking forward is, like everywhere else, we're going to be seeing DEI removal wherever it exists. Next, I think we'll see the non-compete ban die, like Ryan mentioned. It's already been enjoined in federal court, but the FTC still has the opportunity to pursue legal action to enforce it. But that seems widely expected that the agency will just drop their appeal. Looking further than that, I think we can expect a similar stance from the FTC on big business and monopolization as they currently have, since all three commissioners seem to share similar views in that regard. Finally, I think we're unlikely to see many rulemaking efforts coming from the FTC, since Ferguson's view of the FTC's authority is much more limited than Commissioner Khan's. All right, and lastly, we're going to talk about the NLRB. Now, on Monday, Trump removed two key members of the NLRB, Acting Chair Gwen Wilcox and General Counsel Jennifer Abruzzo. Abruzzo's removal was expected since, as we mentioned, President Biden has done the same thing and it's been upheld in court. Now, Abruzzo was active during her tenure, issuing many employee protective memos and guidance, and she prosecuted cases in protection of workers' rights largely. Now, her memoranda identified various areas of law she thought workers needed more protection, like non-competes, stay or pay provisions, and employee recovery. Gwen Wilcox's termination was a little more surprising because under the National Labor Relations Act, the president does have the authority to remove board members, but only upon notice and hearing for neglect of duty or malfeasance in office, but for no other cause. And unlike the termination of the general counsel, who doesn't have those same protections, it's unclear whether Wilcox's termination will stand up to legal challenges, which she has stated she also intends to pursue. Now, if we look at some replacements, replacing Wilcox, we have Marvin Kaplan, who already served as commissioner and now serves as chairman. While serving as commissioner, Kaplan notably dissented from a number of union-friendly decisions, including Stericycle, which Ryan mentioned. We also have Jessica Rutter, who has been announced as the acting GC by Jennifer Abruzzo. Now, if we try to anticipate what's going to happen here, first, with the FTC, like with the EEOC, we'll see a stall in board activity. Can we take a look at the next slide? Sorry, I'm trying to move fast here. I know I'm out of time. Before Wilcox was fired, though, there were already 2 vacant board seats. And with her departure, there are now only 2 members, leaving them without a quorum. So like the EEOC, we'll see a big stall until we get someone else confirmed for the board. Now, because Jessica Rutter was appointed as the GC by her predecessor and they share similar interpretations of the law, I think it's also likely we'll see her being replaced in the coming weeks with somebody similar to Commissioner Kaplan. I also suspect the new GC will rescind a lot of those Abruzzo memos in favor of a more business-friendly stance. And I also think it's likely that Kaplan and the new GC will push a review or reinterpretation of certain legal issues like employee classifications, work rule evaluations, Stericycle, non-competes, and other stuff. Now, to kind of sum up everything I've talked about, I think we can expect more antipathy towards the DEI programs, a slowdown in administrative action, and more business-friendly rules and legal interpretations. Nothing so far that's happened really affects private employers directly, except for federal contractors, but we're watching closely and we will let you know if anything changes. All right, Connor.
Thanks, Josh. I'll be wrapping up our presentation talking about what we can do. You know, we've had a lot of predictions about what we might see, what we've already seen, but one thing I think I can confidently predict is that things will be unpredictable. When you don't know what is going to happen, the best thing you can do is be prepared. Now, I left my Scout uniform at my parents' house, so you'll just have to trust me that I'm an Eagle Scout and I know a thing or two about being prepared. The most important thing you can do to be prepared is to have a plan. So before you face these changes and uncertainty, make sure that you are creating a process that you can follow and everyone knows what to do, so that when these issues and changes come up unexpectedly, you're not asking these questions of who's doing this, who's involved in this update, how frequently do we need to be checking if there are updates, and who do we get to sign all this stuff? And of course, when doing this, you want to be doing it all with the highest quality sources of information that's reliable, up to date, and understandable. Now let's talk a little bit about how you can create that plan. What are these best practices you can be doing when creating your policies? So here on the next slide, we can talk about, you want to create a process. Whatever your process is going to be, you're going to want to take time now to establish this. What your process is going to look like is going to vary from company to company. Obviously, depending on how complicated, how dispersed your employees are, how many employees you have, things will look a little different. If you have, employees in dozens of states, in hundreds of employees, you may need to be frequently checking every month for things that may be impacting your company, right? You need to consider, do you have any employees in new states? Has your company grown? Are there any thresholds that you didn't meet with your previous employee count, but now hiring some more, you have met new thresholds? So you not only need to consider changes in the law, but also changes to your company. One of the biggest questions we get when it comes to thresholds is, who do we count of our employees? And unfortunately, there isn't one clear answer for that. It really will come down to what the law says, and each law can take a slightly different approach. For example, I think the federal FMLA is a great example of this because it uses two different kinds of thresholds. There's that federal, US-wide employer 50 count. If you have more than 50 employees, 50 or more in the US, then the FMLA applies to you, but employees can't use that unless there's 50 or more employees within 75 miles of their work site. So, there's a lot of different thresholds, a lot of different things to be considering. The process, again, will look slightly different for everyone, but we recommend reviewing for legal changes every month. That's what we do here at SixFifty, and that's how we communicate those changes to our users. We think especially when you put in a little bit of time throughout the year, it'll save you from that nightmare of the end of the year trying to collect everything that's happened in the last 12 months. So creating a process, sticking to it, that's being prepared for the changes, and having your process in place is going to help you face those changes more confidently. Now, when do you need, you've got these changes, you've processed, you've got those changes into your documents. What do you do with them now? How do we communicate to the employees? What do they need to sign or acknowledge? So that's going to depend on the type of document you're dealing with. So for example, employee handbooks. One thing that people get mixed up a little bit is that they sometimes think that when an employee is signing an employee handbook, they are signing to follow this, that there's, a bit of a contract. They will follow the things in this employee handbook, but it's important to remember the distinction between a signature and an acknowledgement. Your signature, you're agreeing to this, usually more in the case of like an agreement or some other binding agreement, whereas an acknowledgement, you are acknowledging that you have read this and understood it, and you are aware of what is going on. So it's important to remember that an employee handbook is not a contract. But there are caveats here. There are some required notices and acknowledgements that you might need in your handbook, like a notice of electronic monitoring for New York, or South Carolina specifically requires a disclaimer that your handbook is not a contract on that first page. What you're going to, when it comes to not needing that signature, that means that the approach your company takes is really up to you, right? The most important thing with all of this is that your employees know what is changing. So we think first and foremost, you need to notify employees of changes. Now, when you actually need to get that acknowledgement, it can vary. You might want acknowledgements with every significant change you're making. You might get acknowledgements every year, just kind of collecting those changes that have gone out throughout the year, or you might choose to just get acknowledgements at the very beginning of employment. Now, even if you've gone through and changed all of your documents, your handbook, your agreements, it's also important that sometimes with these things, like with changes to DEI and other processes, you also might need to consider incorporating changes, training, so that employees can actually implement these new processes and and legal changes that are happening. So don't forget to also maybe consider training employees on these new changes, in addition to notifying them and possibly getting those acknowledgements. Now, of course, how do you stay on top of all of this information? We've talked about so much today. There's so much going on. We haven't even dove into how states will be approaching these. So how can you, as an employer, stay on top of these changes? Obviously, you can try and do it yourself, depending on your size of your company. You might have an individual or a whole department applied to this. It can be a real time seek, and it can be especially difficult to stay on top of all of the states you are in if you are a multi-state employer. So obviously, you can bring in outside help. That might be from a law firm or some other third-party service. You'll obviously probably get regular updates about this, but it can be a bit of a difficult process to, send your documents over, get them updated, or incorporate those changes from outside sources. So I want to show you quickly what it looks like at 650 when we are keeping these legal documents up to date for you. So here I have our 650 platform. Of course, we have our world-class legal documents here that stay up to date and current with all of the latest changes. We have also have one of the most robust research libraries. You see here we cover a vast number of topics, all about from hiring, managing, and separating employees, everything you need to know about your employment relationship. Of course, that information is nothing without legal updates. Here I've just pulled up the legal changes that just went into effect on January 1st. You can see that there are over 100 changes across the United States and localities just on January 1st of this year. So that's a lot of information to stay on top of. What does this look like here at 650 though? You see each of these legal updates, we include a brief description of what's changed, any action items you might need to take, and a link to those changes, those documents. So we don't go into too much nitty-gritty detail here because we provide those changes directly into your documents. Here, for example, is a look at those California sick leave changes. Here you can see I've got a red line of these January 1st changes with some changes to the definition of of what violence counts, some additional uses and some additional definitions. And of course, these changes are dropped right into your documents. So they are always up to date, and you never have to worry about the uncertainty of the law as it continually changes and evolves. With 650, we really make staying on top of the law as easy as we can. And when you use 650, you can approach the employment law with confidence. With that, I'll go ahead and toss things back to Ryan.
I'll just mention, these are very sensitive topics. I know that they are affecting a lot of people, and I appreciate sort of how respectful people maintained the chat and the Q&A. We did our best to present these in as straightforward a way as possible, and I hope this was helpful to everyone. Thank you so much for joining our webinar. This has been a fun presentation, and we appreciate your participation. And we hope to see you on a future 650 webinar, maybe even our webinar next Thursday on the state of employment law compliance. With that, we'll close out our webinar. Again, you can expect a follow-up email from us with the slides, a recording, and some information about our webinar next week. We hope this has been helpful, and we hope that we'll see you on a future 650 webinar. Thank you so much.